Joining me now is law professor and former General Counsel to the U.S. House of Representatives, Stan Brand. Stan, Colorado Supreme Court ruled earlier this week that former President Donald Trump will not appear on the state's 2024 primary ballot. And this is all under the 14th Amendment. So can you just start from the very beginning here and describe this 14th Amendment argument for us?
Yeah, very simply, it was passed after the Civil War to prevent former Confederates who had engaged in rebellion from occupying any federal or state office, any judicial office. So anyone who had previously in one of those positions sworn an oath to the United States and engaged in rebellion or insurrection would be disqualified from holding that office. With the caveat that Congress could, by 2/3 vote, lift those disabilities. And in fact, in 1872, and I think in 1898, the Congress did just that. They passed a bunch of amnesty bills because there were so many former Confederates seeking office and coming to Washington to plead for individual relief through private bills. And so they decided to deal with it on a general basis. There's been very little application of this provision in the post-Civil War era. It has come now to the fore because of the January 6th riot at the Capitol. And so there are a couple of cases that emerged. One involved Representative Cawthorn from North Carolina, who was at the rally and made certain statements, and voters in North Carolina attempted to kick him off the ballot. That case went to the Fourth Circuit, where the Fourth Circuit, the only thing the Fourth Circuit held was that the amnesty passed in 1872 was prospective, and so didn't apply to Cawthorn. That case became moot because he lost his primary. Marjorie Taylor Greene had a case in Georgia that was filed against her, and that case went up the chain in the administrative process. And an administrative law judge held essentially that what she had done on January 6th did not involve insurrection, that her statements were essentially puffery and blowing off steam, and she was not engaged in an insurrection through that activity. A county commissioner in New Mexico was actually barred from running for office. He actually had been arrested on January 6th, and a local court held that he was disqualified. And then, of course, we have the Colorado case, and we also have, I think, 12 or 13 other states where cases have been brought and haven't been finally decided. A portion of those cases were dismissed as either political questions or not ripe, and so those are in the pipeline. But this is the first one where the highest court of the state, has ruled on the applicability of the amendment.